Let me welcome you to XReg's webinar on the proposed markets in crypto assets regulation.
Wake up and smell the coffee was a slide I presented a little over a year ago at the V20 conference, shortly after the FATF published its interpretive note and guidance on the inclusion of virtual assets and virtual asset service providers into its regulatory framework. This was a seminal moment, and today I think we're facing yet another seminal moment, because anytime today, we believe, certainly we've been told to expect publication today. It might be later in the week, we don't know. It may well be during the course of this very webinar that the European Commission publishes its new EU crypto asset law. This is going to be called the Markets in Crypto Assets Regulation. Anyone who knows anything about EU legislation will immediately have picked up on the term regulation, because this makes it instantly, once it comes into force, instantly applicable across all member states of the European Union, and because of the nature of this particular piece of legislation, also the three additional European Economic Area jurisdictions, Norway, Iceland and Liechtenstein. Now, the European Commission's been working on crypto for many years. Ernest mentioned, I gave evidence on what was then seen just as virtual currencies over 5 years ago in Brussels. And it's certainly the case that the European Commission and legislators have been keeping an eye on crypto for several years before that. Up till recently, up till last year, and the new commission, the new 5-year commission that came in around about September time, not an awful lot happened with crypto in the EU. But the Commission and the other institutions decided that it was time to respond to demands for a clear legal framework. These were demands not only from regulators and legislators, policymakers and others, but also from the industry. And so they sought, in providing a clear legal framework, to also support innovation, consumer and investor protection, and market integrity, and also financial stability. The extent to which they've found a balance in the proposed legislation will remain to be seen, but you can expect that this legislation, once it comes into force, will have a lifetime of at least 5 to 10 years. Now, I should say that our comments today are by way of a briefing, and it's a briefing based on the authoritative leak that was made of the draft, this 168-page paper by a trusted news source in Brussels, Politico. The final version, when it's published today or whenever, will undoubtedly contain some minor changes, but I don't think we can expect an awful lot to be different. And as it proceeds through the legislative process, we can expect further amendments. And I'll talk about the timeline in a later slide. One thing is certain, and this is clearly set out in the intention that the Commission had when it indulged in several consultations earlier this year, including one public consultation, and when it published a non-paper, as it's called, a policy paper principally addressed at member state governments, sounding out the ideas that it had and some of the options. And through the summer, it's refined those ideas, and now we see what is an almost finished piece of legislation. It's very clear that this is going to regulate all crypto assets and all related activities. And we'll be talking about what are crypto assets, what are the different kinds of crypto assets that it defines, and also which kind of activities are brought in to the scope of this regulation. But essentially, when we highlighted the word all on this slide, we meant all. there really doesn't seem to be much scope for anything to fall between the cracks. For starters, the regulation aims to set some rules for token issuers. And as you'll see shortly, token issuers cover pretty much the issuers of all kinds of crypto assets. And it also defines what needs to be included in white papers. It turns some types of stablecoin into e-money. And e-money is something that's been regulated for some time, so it immediately sucks in those regulations and legislation that already exists. It imposes a set of very strict rules on what are referred to as asset reference tokens, and we'll explain what we mean by asset reference tokens as we go through this presentation. And it also brings significant stablecoins, that's the word that's used, significant stablecoins, under government control. It establishes essentially an EU-wide authorization and supervision regime for crypto asset service providers. So if you're familiar with traditional markets legislation around the markets in financial instruments, you may know it by its acronym MiFID, then you can look at roughly parallel types of activities and see how all those parallel crypto-related activities, or at least most of them, seem to be drawn into this new regulation. And this regulation is not just going to be additional to any of implemented legislation for crypto assets or some aspects of crypto assets. It is very much the case that when this regulation comes into force, everything else in this particular space, national legislation in other words, melts away. It disappears and it's replaced by this new regulation. Without a doubt, certainly in my mind, this is going to have a profound impact on crypto assets and everyone who's providing crypto asset services. So let's look what we mean by affecting all crypto assets. Well, a slightly praised definition, but essentially the definition that's proposed in the draft is a digital representation of value or rights which may be transferred and stored electronically using distributed ledger or similar technology. It's a very broad definition, and it pretty much brings into scope every kind of token and coin that certainly I've seen over the last 10, 11 years in this particular space. And when we say it's going to affect everyone in crypto, it basically means those who issue crypto assets, or at least if they want to offer them into the European Union or have them traded in the EU. Indeed, anyone offering crypto assets in the EEA, and also this new category of financial intermediary, I will use that term loosely, known as a crypto asset service provider, or CASP. And in bringing in CASPs, it will also regulate crypto markets, not only the operators of crypto markets, but also market conduct, market abuse, the use of the misuse of information, and so forth. But having said it covers everything, let's look at this perhaps from the bottom of this pyramid working upwards. We say that it really covers all crypto assets, that which I've just defined, or which is defined in the regulation, but which I cited in the previous slide. All crypto assets, including utility tokens, are considered to be crypto assets. There's then a layer on top which says, but if you're a stable coin, and I'll come to what the definitions are of stable coins in a moment. If you're a stable coin, you're going to have to consider some additional rules. And in determining those rules, you really have to put your stablecoin, I guess, into one of two or potentially three categories. If it's a stablecoin that is referenced by a single fiat currency, then it's going to be an e-money token. And it'll be subject to specific rules as an e-money token. If it's referenced to any other kind of asset, that could be a basket of fiat currencies. It could be other cryptocurrencies. It could be other assets altogether, physical or other assets. Then it will be deemed to be an asset reference token, and it will sit with some separate rules of its own. And as you can imagine, as we work our way up this pyramid, we will find ever stricter rules and regulations. So from the base set of regulations that we have applying to all crypto assets, we work up through stablecoins, and eventually at the peak, we find significant tokens, significant stablecoins of either type, which are subject to the most stringent set of rules. Now, when we look at what aspect of crypto assets fall within regulation, and please bear in mind that this is a briefing today. This is a very high level overview. This is not an analysis of either the law as it might be if it takes the form of the draft that was leaked, or the finished form today, or indeed the finished form when it eventually comes into force. But in broad terms, we can say the key requirements relate to offerings of any kind of crypto asset, including utility tokens. First and foremost, the issuer of the token, if the token is to be offered or traded on a market in the EU, the issuer has to be a legal entity. Typically what we mean by that is a company, although there may be other variations around legal entity. It has to issue a white paper with certain prescribed required information. And although at its base level, that required information doesn't necessarily have to be pre-approved, that white paper and any marketing communications have to be notified to the national competent authority where the legal entity is established. And finally, the regulator has, or each regulator, I should say, will have powers in effect to intervene. So it can require changes to be made to the white paper. It can require an offering to be halted or suspended, or indeed it can publish a notice, a public notice to the effect that a particular issue is not compliant with MiCA. Now, there are a whole set of other provisions, but I think we can say these are the key requirements that are going to affect all crypto asset issuings and offerings. So I'll hand over now to Anna to talk to you a little bit about stablecoin requirements.
We will be issuing a detailed paper over the next week or so on MiCA. If you'd like to get a pre-release of this document or any other future publications or invites to webinars that we may issue, please feel free to subscribe on via the URL which is on the slide.